Judge Tom Malone. The first case we have in our docket is 127-653, SoftServe versus NetSmart. The parties want to enter their appearances.
Your Honor, Michael Raup and William Keeley on behalf of SoftServe.
Morning, Your Honor, Pat Fanning and Emma Hoffman on behalf of NetSmart.
All right, are you ready to proceed?
We are, Your Honor.
Okay, would you like any time for rebuttal?
I'd like to try to reserve 3 minutes if possible.
Sure. I should double check. I have this down for a 15-minute argument. Is that what you all have?
I believe that's correct.
I always want to make sure that way if we don't get started and somebody thinks they were to have more time. Let me get my timer set up here. You ready to proceed? Okay, thank you.
Thank you, Your Honor, and may it please the court. All this court must decide to resolve this appeal is which contract term controls NetSmart's termination of the contract. As a matter of law, the only provision that could have done so was found in Statement of Work number 7, and it requires an early termination payment to SoftServe. This must be the result for 3 primary reasons. First, it is required by the text of Statement of Work 7 itself, a contract the parties agreed to just 1 month before NetSmart's termination. NetSmart knew that an early termination would result in payment, and it terminated the contract anyway. Second, the alternative provision that NetSmart originally attempted to invoke, the termination clause in the Master Services Agreement, or the MSA, cannot apply because its terms directly conflict with those in Statement of Work 7, and the parties expressly agreed that the Statement of Work controlled in that exact circumstance. Third, NetSmart's post hoc rationalization for the termination, invoking the force majeure clause, also cannot work as a matter of law. By its own terms, that provision could not apply to terminate a contract until 3 months after the force majeure event began. And by that time here, there was no longer a contract to terminate. This case is one where the plain language of the contracts dictate the result of this case. For all the talk in the district court's order, as well as in NetSmart's briefing of the events that were unfolding in Ukraine and the potential force majeure impacts of those, they do not have a bearing on this case. Put simply, this is a termination case, not a force majeure case. For these reasons, the court should reverse and direct that judgment be entered in favor of SoftServe. And we'll begin with, I think, what is most critical in this case, which is NetSmart's own language, what it actually did when it invoked these provisions. And that's found in the record on volume 3, page 58, and that's NetSmart's termination letter of February 28th. That letter very clearly does 2 separate things. It first invokes the force majeure clause, but it only does that to forgive NetSmart's own non-performance with specific obligations that were outlined in the contract. But then importantly, near the end of the letter, it does a second separate thing. And by no uncertain terms, using no qualifying language whatsoever, that NetSmart says it is also hereby providing notice of termination pursuant to the Master Services Agreement. And I'll come back in a moment to why the invocation of the MSA is incorrect. But I think it's also important to articulate now what that letter did not say. It didn't invoke the termination language of the force majeure clause. And again, that makes sense because that language wouldn't have even been possible to invoke until 3 months down the road.
Counsel, is it relevant that in this February 28 letter, that the section of the Master Services Agreement that NetSmart referenced is the section that also requires the 90-day notice of termination, which is the same amount of time as the force majeure 3 months requirement?
A couple of responses to that. So I think it's relevant in a couple of ways. First, it's relevant because it conflicts with Statement of Work number 7, which is a 30-day notice provision. But to your point about them lining up and being the same, I think it's significant only in that the notice provision here is self-executing, right? Not you give 90 days notice and the contract is terminated. Whereas if you look at the language of the force majeure clause, right, the last sentence of the force majeure clause says that if it continues for more than 3 months, either party may terminate the agreement. right? So it's not self-executing. It vests a right in the party. And that's a critically important fact here. And I think we'll come back to this several times throughout the argument today, because as a matter of fact, once those 3 months elapsed, there was no action from NetSmart whatsoever. So whatever hypothetical that NetSmart wants you to engage in to go down that road,
You mean there was no action by NetSmart?
once that right had vested. So say it's 3 months after, so it would have been sometime late May. There's no letter from NetSmart that says we're now terminating pursuant to the force majeure
But you'd
clause.
already terminated by then. You'd sent it in, what was it, April? They sent the early termination notice. And so what was NetSmart supposed to do in May when SoftServe had already terminated in April?
Well, I don't think it's correct to say that we had terminated. We had sent a final invoice pursuant to the early termination payment. But if NetSmart's position was that this contract was still operative and that they were still waiting to see what happened with this force majeure event, one would think you'd certainly see in the record some invocation of that termination provision if that's what they intended to use to terminate the contract. But that doesn't exist in the factual record. The correct
Is the termination under the master services agreement they referenced in the February letter, is that also self-executing?
Yes, that is self-executing. The force majeure, I don't believe is. I don't think there's any reading because of that permissive language. Either party may terminate. So they've got to take some sort of action to do it.
So why can't we find that they were just hedging their bets in this February letter? Like we're invoking the force majeure, but hey, if we foresee this conflict extending beyond 3 months, so we're going to also go ahead and terminate the master service agreement and give you that 90-day notice at the same time.
I think there's several reasons. First of all, because they didn't say that in the February 28th letter. And importantly, in that February 28th letter, what they also did is they say, we will pay for services up to February 28th, and that's it. So, and that's in the second paragraph. In the event payment becomes due, it will pay for services up to the 28th. This is very clearly, they terminated the contract as of February 28th. Now, again, they invoked an inoperative provision to do so, and I'll get to that. But
didn't they also continue using the services of your one employee in Poland after this February letter?
Now, certainly the parties were still attempting to work out. They could have revoked a termination notice at some point, and the parties were, of course, I mean, this is a contract for both of us, and SoftServe stood to benefit from a continued relationship, a relationship that they'd had for years, and they were working to resolve that. But it doesn't change the fact that there's a very clear and unequivocal termination. And importantly, again, if the point would have been, we want to wait and see what happens, you wouldn't have that unequivocal termination language at the end of the letter. And so what then we have is that termination, and what is the legal effect of that, and what is the operative document that has to then govern that termination. And so you're left with, is it the MSA or is it statement of work number 7? And I don't see any realm in which there's not a conflict between those two. Statement of work number 7, again, signed by the parties just a month before this, very clearly has a formula.
What relevance does the execution of the agreement a month before the war started? Neither party knew that was going to happen.
That's right.
So what relevance is a month before?
The relevance of a month before is that they knew that the early termination language was in there, and that they were going to, if they terminated the contract early, they were going to be required to make an early termination payment. And that's known by the parties, and the temporal proximity of the execution of the agreement just illustrates that this was negotiated shortly before this. I take your point, Your Honor, that there were unforeseen circumstances that developed, and that very well, again, we can contest whether that's a force majeure event under the language of the contract or not. Our point for purposes of this appeal is that it doesn't matter, because there's a separate termination invoked of this contract. They chose to terminate the contract separate and apart from invocation of the force majeure clause. So then the question becomes whether that clause in statement of work number 7 or whether the clause in the MSA is the one that controls.
And am I correct? The MSA is kind of the overarching agreement, and the individual statements of work are separate services that are performed and individually defined under each statement of work.
Exactly right, Your Honor.
Subsets of the.
Exactly right, Your Honor.
Were there any other statement of work that were in effect at the time of this termination in February? Was it just number
I
7?
believe that number 7 was the only operative statement of work. That's my recollection from the record.
So if the way I read the statement of work, if you want to terminate the statement of work, then it's got an individual termination clause, correct?
Correct.
And it talks about, for example, in section 11, it says either party may terminate this statement of work.
Right.
I mean, both 11.1 and 11.2 start out with those language.
That's
and
correct.
They just separate between whether or not it's with cause or without cause. And so why should I not read that language to indicate that those termination clauses are only operative if I'm trying to terminate the statement of work and not the overarching master services agreement?
The problem with that interpretation, I believe, Your Honor, is that it's very clear from the first paragraph of this statement that, as you described, these statements of work are occurring under that master services agreement. So that interpretation, I think, would be inconsistent with the purpose and the clear direction of the parties that there was going to be an early termination fee. If there was going to be a backdoor way to circumvent that, I don't think that effectuates the intent of the plain language intent of the parties. If they could just say, well, we'll terminate just the overall agreement and it will have no impact on the statement of work. I think that's because, again, it's very clear that the parties contemplated that if this specific statement of work went away before its expiration, it had to be pursuant to an early termination fee. An early termination fee that has a specific formula, very, very defined term on what has to happen if this contract is terminated early.
Is there any relevance to the difference in the notification timeframes between the master service agreement and the statement of work? Because if I terminate under the master service agreement, I have to give you 3 months. But
Right.
if I terminate statement of work, it's only 1 month.
Right.
And so, maybe if I give you 3 months notice, then you have more time to find alternate work, find a substitute,
Right.
something to do for these people instead of this particular job. Is there any significance between those different timeframes?
Sure. And a couple of responses. First, I think it's significant in that it would typically be of a greater benefit to the client, right, to have a shorter duration of a termination clause. But I think the only legal impact that this has here is that because this is the contract that governs statement of work number 7, I think the right way to, if you're to write an opinion directing judgment in favor of soft serve, I think the right way to do it is based on the 30-day notice period. But I guess my point for the overall outcome of this case is that it wouldn't matter, because even if you said that it was going to be may I finish the answer?
Oh, absolutely.
Thank you. Even if you were going to say that it's a 90-day window, we're going to give them the benefit of that 90-day window. We come back to the discussion we had at the beginning, which is regardless of whether it's 30 days, 90 days, there was never an invocation of the force majeure termination clause after that right had vested. And so irrespective of what the time frame is, it's a termination under the without cause termination provisions as a matter of law. And then it's just a matter of whether the early termination fee applies. The statement of work number 7 deals with those contrary terms and resolves them in favor of the statement of work.
Why is it a termination? You just mentioned it's under the without cause provision, but the cause of the termination ultimately was the force majeure event. So why wouldn't that be a termination for cause for a reason?
Well, a few responses to that. First of all, it's a without cause termination based on NetSmart's own language in that February 28th letter, because the provision that they invoked, the provision of the master services agreement, is the without cause termination provision of the MSA. So if they wanted to invoke some sort of for cause provision, their opportunity to do that was when they actually made the termination. And so you know that it's a without cause termination because of that. Also, Your Honor, I think to accurately determine what constitutes for cause and without cause, those terms have to be read in concert with one another, right? So there's a without cause termination provision, and then both of these contracts also have for cause termination provisions. Material breach of the contract and bankruptcy of one of the parties. Those are what constitute for cause. So cause can't be understood just in isolation because, of course, anytime a party gets out of a contract, there's always a cause for it. Business reasons, we just don't like the people we're working with, whatever it is. So if we allowed those to, sort of smuggle those in as for cause, then a without cause termination provision is never going to have any applicability in any contract.
In order to preserve your rebuttal time, I just wanted to let you know that you've gone into that.
Okay.
But I do know that I ask a lot of questions, so I want to make sure that.
I have
do you
no
two-
questions.
Okay, then I guess we'll see you on rebuttal.
Thank you, Your Honor.
May it please the court.
Absolutely. Let me adjust my timer so you get your full 15 minutes and not just 12.
Thank you, Your Honor.
Okay. You both ready?
NetSmart respectfully disagrees with the position that SoftServe has taken with respect to whether a termination was effected on February 28, 2022. NetSmart did send notice on February 28, 2022, and in that notice, NetSmart provided notification that it was invoking force majeure and also that it was terminating the master services agreement under Section 5. Now, that notice of termination was a 90-day notice. That meant that there were 90 days left in the contract. Even if something, as counsel referenced, if the contract would have, if the force majeure event would have ended, it's possible they could have sat down and renegotiated. In fact, if the court were to delve into the letters that went back and forth between the parties, that was certainly always contemplated.
Then
But-
why'd you say, as he pointed out in your February 28th agreement, that you were only going to pay for those deliverables completed and or services performed before February 28th, which was the date of your letter?
Because at that point, we did not contemplate further services as long as the force majeure event was in place. That was what that letter was intended to convey, because at that time, as the court mentioned, there were, I believe, 20 of the 21 SoftServe employees were located in a war zone. There was one in Poland. And by the way, as the court alluded to, NetSmart continued to work with that associate, that employee that was in Poland, which was out of the war zone. And I'll jump into that in a minute, but before I do, we have a 90-day period there regardless. We did not invoke anything other than that this contract is going to terminate in 90 days. What SoftServe has done is they've tried to present a binary choice based upon a statement in the statement of work, Section 11 of the statement of work. What they're saying is there's only two ways that a contract can be terminated based upon their worldview. One is the for cause provision in Section 11, which requires a breach of contract, or without cause. Those are the only two options they give. I would argue that the MSA itself does have at least a third option, which is force majeure. And also there's a Section C, which allows for termination in the event of insolvency. The statement of work doesn't contradict. It's not inconsistent with those other terms. It doesn't rewrite the underlying contract. Those terms continue to exist. But in any event, under the termination without cause provision of statement of work number 7, it only provides that NetSmart needs to provide at least 30 days notice. It doesn't suggest the contract will terminate within 30 days after NetSmart's provision of notice. NetSmart provided 90 days notice, which again on the calendar would take us out to about the end of May. Now, what SoftServe did, and it is undisputed, is that SoftServe on March 31st of 2022 cut off the access to the only employee that was not in the war zone. And on April 6th, SoftServe served and sent NetSmart a termination invoice. And that termination invoice terminated the contract. Termination had not been reached. We may have given notice, but we were still under an active contract. There's no question, no one has cited law to this court to suggest that we were still not parties to a contract and should have been parties, even if you assume everything in SoftServe's favor through May 28th. The fact that SoftServe terminated the contract unilaterally at that point, cut off any further obligation NetSmart had to communicate at that point. The court, however, the trial court correctly identified the most important piece of this, which is we invoked force majeure. It is undisputed that the war in Ukraine is a force majeure event. It is undisputed the force majeure event continued through the day that we had our hearing on the motion for summary judgment. And although not a fact today in the evidence, it continues to this day.
But this case isn't that simple, though. Yes, there was a war in the Ukraine, but the force majeure clause becomes effective if the force majeure event causes the non-performance under the contract. And aren't the parties disputing whether the war actually caused NetSmart from being able to perform?
I would argue that is soft serve argument, soft serve's argument.
Well, I know that's their argument.
but
They presented a whole bunch of emails and documents to that effect.
NetSmart's perspective is that a force majeure clause can be self-effectuating in the event of a force majeure event. So there is a war. We all agree there's a war.
Right, and the judge looked at it under those simple terms. There's a war, there's still a war. But did the judge ever even analyze all the evidence about whether the war caused NetSmart's non-performance? There seems to be quite a bit of competing evidence on that. And in terms of your motion for summary judgment, aren't we to look at the facts in the light most favorable to soft serve?
And NetSmart's perspective on that issue would be, yes, you would look at the facts most favorably to soft serve under the Miller case, obviously. But NetSmart's position would be that that is an improper reading of the force majeure clause in the party's contract. Because if you were to require people who enter into contracts to do a hindsight analysis of whether they actually were in danger, then that would obviate the whole point of a force majeure clause. The force majeure clause is, I am looking at a potential danger, whether it be war, civil unrest, hostilities, hurricanes, whatever it may be. And I'm making a call at that point that we're going to say all bets are off and I'm going to pause my performance because that's what's going on. It doesn't matter what subjectively I'm thinking, because if we do that, then every time if a war's not quite as bad as we thought, then you could be liable.
And that's what the judge said. The judge said he doesn't need to look into the psyche of the parties. I think those were his words. But the force majeure clause says you're excused from non-performance by events caused by the circumstances. The word caused is there. And then it gives several examples, including war. And the judge just said, well, it's undisputed there's a war here. And granted summary and found that the facts were in favor of you supporting summary judgment. But my suggestion is the case that simple?
And Your Honor, I would respectfully submit that it is, because the way we interpret this clause is the clause says that no liability shall result from the non-performance of any obligation caused by a force majeure event.
Right.
So we have non-performance that is caused by a force majeure event.
They're disputing that, though. They presented a bunch of evidence to dispute that even.
They don't dispute that there's a force majeure event.
Correct. That's correct.
Yeah,
They
so-
don't dispute that there's a force majeure event. They're disputing whether that force majeure event caused the non-performance.
And that's where we disagree, because we think if you were
You disagree.
if you were able to take a subjective viewpoint in hindsight after the event has ended and to determine whether it might have been okay for someone to put their resources at risk. In this instance, the undisputed facts show that the U.S. federal government was issuing warnings about data privacy issues, the security issues that were a great concern in Ukraine, and NetSmart, again, not having to explain its psyche, but NetSmart, a company that works in healthcare data and patient clinical data, electronic health records, which are protected under our laws by HIPAA, NetSmart made a decision not to place their assets and their client and patient data into harm's way. I don't think that analysis needs to be done, because I don't think that a force majeure clause is subject to well, was it as bad as we thought it was? Maybe that war wasn't too bad.
Well,
Because-
you're bound by the language of the contract that your client negotiated, and the master service agreement allows for the force majeure to continue. It gives it a 3-month time, or depending on how, whether the force majeure is ended within that 3 months, or when the non-performing party has taken the steps which it could reasonably have been expected to take to overcome the force majeure. So your client had an obligation to take reasonable steps to try to overcome the force majeure. And what findings of fact are there in the record below to support that your client did that?
Well, there's a couple things, but the first statement I would say is, practically speaking, when you're dealing with war, we can't overcome a war. That's
No one's
just
asking you to overcome the force
Understood.
majeure, but to mitigate the effects of it on the services.
and the undisputed evidence is we tried to do that. The undisputed evidence is that
What findings of fact are you referring to in the summary judgment record that you tried to mitigate? I mean, I see there's findings of fact about this generalized concern about malware and HIPAA concerns, but I don't see findings of fact, and please let me know if I'm missing them, that relate to what your client did to address the issue, to address the potential for malware, to protect its system, to work with people in other locations, because the statement of work mentions that the work can be done in other places, Poland, Bulgaria, US. I mean, to explore those options. I'm not saying it didn't happen. I'm just saying, where in the record can we find that it did?
Okay, it's undisputed in the record. First, as I mentioned, Mr. Yanko, the Poland-based employee of Ukraine of SoftServe, we continued to work with him. That's an undisputed fact in the record, which shows that NetSmart was interested in continuing to do work with the non-Ukraine-based employees of SoftServe. But then, as a general matter, it's also undisputed that the day after we signed Statement of Work number 7, so that's January 24th, 2022, on January 25th, SoftServe presented NetSmart with a business continuity plan. And in that business continuity plan, SoftServe expressly advised NetSmart that in the event of a war or escalation, they would take the escalation up to level 2, which was to relocate their employees outside of Ukraine.
To Latin America.
Well, to Latin America, but outside of Ukraine. They could have gone into the European Union as well. They claimed it would take 9 to 12 weeks. What ultimately happened is they didn't do that. Even though they sent an email on February 24th, the date that the war broke out, they sent an email telling NetSmart that they were invoking level 2. They then chose not to relocate the employees, which was what level 2 was intended to do.
But in the summary judgment, journal entry of judgment, it says you rejected that business continuity plan.
We did not. We rejected the proposal they made a month later, which doubled the cost. So it changed. It was a new contract that they proposed. So the statement of work had a maximum amount that could be spent. What they told us is, yeah, we'll relocate the employees, but it's going to be twice as much.
But again, we're talking about what SoftServe is doing. And my question is, what's the non-performing party, NetSmart, doing to attempt to overcome the force majeure? Where's that in the record?
Well, so my suggestion would be that these discussions that we're having about mitigation and working with SoftServe is an attempt to get that mitigation that you're talking about and to overcome the force majeure by getting those employees out of harm's way, which did not happen.
Basically, you're both arguing, though, about whether the other party took reasonable steps and made reasonable efforts. And that word reasonable, doesn't that always, or more often than not, require findings of fact to resolve? In other words, jury trial resolution, as opposed to summary judgment.
Respectfully, I would argue that we're not arguing about reasonableness with respect to the conduct. What I'm saying is there is ample evidence that the court found in the record of efforts by both parties to try to overcome the force majeure, which could not be overcome because employees were not relocated. Whether reasonable or not, I don't think matters. They just weren't relocated. They were kept in Ukraine. And as a result, we were in a
Their
situation.
answer to that was, though, that by the time they made that decision, you had already terminated. So
Except that,
again, looking at the facts in the light most favorable to the non-moving party, I think there's a possibility that maybe neither summary judgment motion should have been granted.
well, Your Honor, there's no dispute. There's no dispute that the that the notice of termination was sent and that we were within that 90-day period. There
Are
is
you
no,
talking about your notice?
Our notice
or
of
their-
termination.
Okay. 'Cause-
On the 28th.
on February 28th, and we're within the 90-day period. There's no dispute about that. There is no dispute that the contract was not terminated during that interim period. Could not be legally, at least based upon the notice we provided. And there is no dispute that SoftServe took unilateral actions that did terminate the contract.
What's your response to their argument that you were invoking the termination without cause provision in the master service agreement back in your February letter so that you were proceeding as if this was a termination without cause?
Well, there's absolutely no evidence of that one way or the other, because first, that's not what the letter says. The letter says we are invoking it under 5B1. 5B1 does not speak in the term of cause or without cause. 5B1 merely says that we may terminate the contract with notice. There
But
is
5B2 talks about terminating if the other party breaches or if their failure to cure the breach, and 3 has to do with whether they're insolvent, which are both causes for termination, correct?
Well, they would be causes, yes. But the master services agreement doesn't speak with respect to cause or without cause. That's my point. And 5B1,
Why is that not implied in 5B1 if you're allowed to terminate terminate the agreement with 90-day notice? Why is it not implied that that's a without cause termination?
because you could terminate for force majeure, which would be a type of cause, not the traditional breach, but it would be a type of cause, which is what the district court found. And additionally, Your Honor, Delaware law does not allow us to imply things in contracts, which is why, they want to try to box the statement of work termination provision into meaning that counteracts or changes MSA Section 5's termination provision, and it does not. They're not inconsistent provisions.
Why are they not inconsistent I guess my question is, if you can enforce 5B1 in the master service agreement, why does that not render the termination clause in the statement of work for termination without cause a legal nullity? I mean, what's the point of even allowing the termination without cause and requiring the early termination fee if you can just skip that step and jump to the master services agreement?
And NetSmart has not suggested that we could do that. What I'm saying in this argument is if we had no other cause, and we have a very big cause here, which is force majeure, then we wouldn't be able to sidestep if we truly had a termination without cause. But no one at any point on the NetSmart side has suggested this was a termination without cause. There was cause. It was force majeure. The notice of termination, I might add, by the way, again, we didn't terminate. We gave 90 days notice.
But you also said you wouldn't pay for anything after February 28th.
As far as current services went, that is correct, because there was a force majeure event that was ongoing in Ukraine.
So what function does the 90 days do?
Well, it allows us to, as we did do, is continue work with, for example, Mr. Yanko, who was in Poland, the SoftServe employee. So we continued to operate as if we were under the contract until March 31st, when SoftServe unilaterally terminated Mr. Yanko.
So you continued to pay for his services after February 28th?
We continue to work with him. I believe we continue. I don't have that in the record, but that's,
That was the intent.
yes.
All right.
Any other questions?
Do I have any time left?
No, but if you want to take a little bit to wrap up, that's fine.
Yeah, just as one final issue, we feel pretty strongly that the court got this right at the district court level. However, if for some reason the court were to not affirm the district court's opinion, there's no scenario by which SoftServe should be able to obtain summary judgment, because there are many disputed facts about the things we've discussed, which are the events that took place after February 28th. We think they're irrelevant to the overall dispute as it currently sits. But again, if SoftServe, if the matter were to be overturned on appeal, these are very factual issues that would need to be discussed. Thank you, Your Honor.
Let me get you your 3 minutes. You ready?
Yes, thank you, Your Honor. 3 quick points on rebuttal. First, Judge Malone, you're exactly right that if we get to the point where we're evaluating whether the force majeure clause applies or not, there are disputed factual issues, both about whether the force majeure caused the non-performance of the contract and also about whether that event could have been overcome. Those are disputed throughout the record below. And so if you get to the point in the analysis where we reach application of the force majeure clause, the only appropriate remedy here is remand to the district court. The second point is that I don't think you need to reach the force majeure clause, because I think this is decided by the February 28th letter and the clear separate invocation of a notice of termination. And I want to be clear because we had some discussion about 30-day notice period, 90-day notice period, whatever it is. The February 28th letter does not say we're providing 90 days notice of termination. It says we are terminating the contract pursuant to, and then cites the term. But the problem is that that conflicts with statement of work number 7, both in terms of the notice period and in terms of the requirement of the early termination payment. And so if this court finds, as we believe it must, that the notice effectively and unequivocally invoked termination of the contract on February 28th, statement of work number 7 governs. There are no disputes of fact. There are no discussions of fact that need to occur beyond that. Those are simple reading of the contract language. And so if you look at the contract that way,
do we just have to look at that February 28th letter? I have a feeling maybe NetSmart regrets adding that very last sentence there to the letter at this point. But the fact is, the conduct of the party shows that they were continuing to try to work together even after February 28th.
And they can, because I want to be clear, Judge Malone, that we could have convinced them to revoke that termination.
So why do we have to conclude as a matter of law that this thing was terminated on February 28th?
Because there was an effective notice of termination that was never revoked. That's the simple answer, is that there's a notice of termination. And if that's governed by statement of work number 7, it's a 30-day notice period.
It just seems to ignore the rest of the evidence that's in the record.
Well, I don't think that the evidence in the record matters unless there's a revocation of that termination, because it's unequivocal notice of termination of a self-executing termination provision. So I think as a matter of law, that requires the payment of the early termination fee. And again, if you get to the force majeure impact of this, I do think you have to remand for further factual findings. But I don't think that's true if you look at the exact contractual termination provisions. Delaware law is clear. Good deals are made, bad deals are made. We enforce them all equally. And that's what SoftServe is asking the court to do. The court should reverse and remand for entry of judgment in favor of SoftServe. Thank you.
Thank you.
We appreciate everybody's briefing and arguments today, and we will take this matter under advisement and issue an opinion expediently.
Thank you, Your Honor. Thank you.
Good morning. The next case we have on our docket is case number 126-188. And when the parties get settled, let me know and you can enter your appearance. Okay.
May I ask a question?
Absolutely.
This is my client, and I really don't recall if it's appropriate for her to sit at this table or should she sit out in.
You might be more comfortable if you sit at one of the chairs against the wall, maybe, or obviously the row in front, whichever one is comfortable.
May it please the court. The appellant appears by and through her attorney, Rosie M. Quinn.
Thank you.
Your Honor, if it please the court, appellee Ryan Watson appears by counsel Rick Greenwood.
Thank you. Ms. Quinn, did you want to reserve any time for rebuttal in your argument?
Yes, Your Honor. May I reserve 5 minutes?
Yes, you may. And feel free to proceed to the podium whenever you're ready.
Good morning.
Good morning.
It is truly my honor to be here. And I would like to thank everyone for accommodating me. The court granted plaintiff's summary judgment motion because it said, among other things, she did not comply with Supreme Court Rule 141. Even if that may be true in certain respects, it was improper because the pleadings and materials on file didn't show plaintiff is entitled to judgment as a matter of law. Undisputed that the title to the property in question was in the name of the Marguerite P. Walker Trust, dated February 3rd, 1997. The plaintiff, Watson, is apparently relying on Marguerite Walker's marital status at the time she had executed the deed to the first person, Benny Gibson. And it's interesting because according to Supreme Court Rule 141, a person must do more than just file a motion for summary judgment. My interpretation is that it should be accompanied by a brief or memorandum that sets forth the law to support its position. In this motion for summary judgment filed and granted by the court, there was no reference to law, no reference to cases. They were just generally bland assertions. But what we're asking the court to do is to make a determination that at best, this motion for summary judgment, the granting of it was premature. Ms. Walker filed a motion for a declaratory judgment. She also filed a document asking that the title to the property be quieted in the name of the trust. The court never addressed those issues. But in this particular case, no one disputes that the title to the property belonged to the trust.
Does anybody dispute that Ms. Walker signed the deed to was it Mr. Gibson?
I don't think that's in dispute either.
So
But,
would the deed would have been valid had she just put Ms. Walker trustee?
well, I can only go by the law. And the law says that any conveyance of land in the name of a trust must give some indication in the conveyance that a trust is involved. So I guess we have on one hand the fact that Miss Walker may have transferred that quit claim deed to Benny Gibson. And on the other hand, the law that tells us that it must be some indication in the transferring or conveyance document that a trust was involved. So the question becomes, even though Watson might have a quitclaim deed to the property, does that make his deed superior to the Marguerite P. Walker Trust? And I submit to you, it does not. Now, panel, I am only addressing the motion for summary judgment that was granted. But there were other issues the district court had brought up. The district court had made some other references to how the trust document was never presented, made references to Mr. Watson may have possibly claimed the property under a theory of adverse possession. And I disagree with that. We know that adverse possession requires, in addition to open and notorious, hostile, that it requires a continuous interest or possession. Even if you start with Benny Gibson, no one continuously possessed this property for 15 years prior to this petition being filed. And then for the court to say that Miss Walker Yeager should have come forth with the trust documents. Another big problem with this case is that there really isn't a record insofar as there's no indication anyone ever asked for it. There was no discovery done. I believe the court could have ordered Ms. Yeager to produce the document. I believe,
Produce what document?
pardon me,
What document are you saying?
the trust document.
Okay, did you brief the argument of adverse possession in your brief? I don't recall reading that.
Well, only in passing, Your Honor. Only in my comment that, one second, as it related to the fact that the court had mentioned it in its memorandum decision. that about 15 years. I think the court had said something like Ms. Jaeger had an affirmative duty to take some action to protect any interest she may have had before 15 years after the first conveyance. And my only reference to that is none of the people, if you combined Gibson, Adams, and Watson, none of them were in possession of that property 15 years continuously. If an adverse position, pardon me, if an adverse possession is what the court was adhering to. Now, again, we're simply asking the court to remand this case so that the facts can be developed. There's no testimony about where the trust document is, but we know there is a trust document, and we know that it existed at least as recently as 2019. But to just enter an order saying that the plaintiff appellee owns this property based upon the records and the files and the pleadings. And remember, the plaintiff himself had entered into evidence a document by a title insurance company that said the title to that property was vested in the name of the trust.
Counsel, you are going into your rebuttal time, which is your prerogative. If you want to do that, I just wanted to make you aware.
Thank you, Your Honor.
Thank you.
Ms. Quinn, members of the court. First of all, Judge, you are correct. Had there been a one word added to the original deed in 2008 trustee, we wouldn't be here. And just so everyone knows, there was 3 conveyances in 2008, 2014, and 2018 to my client. Now, I'll admit this case had kind of tortuous progress from the beginning. The whole case transpired when the Wyandotte County court filing system was down because the unified government had been hacked. And so we had no access to computer filing. So most of the action took place on Judge Clapper's motion docket, which is a monthly docket. Throughout almost the entire case, appellant was pro se. The court urged her to hire counsel. But I will also note at the very end, when we actually argued the summary judgment motion, she did have a prior counsel, Mr. Zimmerman, that argued it to the court. So she wasn't pro se when the summary judgment was argued. The court had a couple of bases for its ruling. It did find that she failed to comply with Rule 141. I think it's mainly because about 12 months of litigation and the summary judgment motion, she never produced a copy of a trust. It's kind of hard to say it's owned by a trust if you can't provide a copy of the trust. So we don't even know.
But counsel, you didn't produce a copy of the trust either, correct?
No, we don't.
And you were the party moving. I mean, what's your response to your friend on the other side's argument that when you move for summary judgment, you're obligated to support that motion with documentation to show you're entitled to that judgment?
Well, the only documentation we have is the title report that showed that was titled at one point in the name of a trust. It didn't say irrevocable, it said trust, okay? But we'd have no way to know where that trust document is. But it brings us to the second point, Judge. The court did not just find this based on Rule 41. He based it on equitable issues. Now, he never said adverse possession. But he said after 14 years with 3 separate owners, paying the property taxes on the building, I think under the documents of waiver, estoppel, or maybe latches, that they had an affirmative duty to come forward and contest this. Now, without them producing the trust, we don't even know who the successor trustee is or whether she's even the beneficiary in this case. So, what do? I have to file for summary judgment at some point in time to get this case moving. I think what actually happened was no one's doubting, questioning the fact that this trustee grantor would have had the power to convert the asset into another asset. And I think that's what happened. I think she sold the house, the cash went in the bank, she died shortly thereafter. The money was distributed, and only when the appellant was served by the sheriff with us trying to quiet title did they assert their claim. I think the two cases that appellate cites are distinguishable. In the Midwest case, it was a husband-wife trust. Husband dies, wife tries to convey it to another trust to keep husband's kids from getting any money. So in that case, the grantee had full knowledge of the original trust and its terms. Same thing in the second case. What's that called? Well, it's the church case where a local congregation tried to take title away from its national organization. And once again, in that case, the grantee had full knowledge of the trust. And in both cases, they were trying to do something they're trying to hurt somebody. They were doing something unscrupulous. Where in this case, we have three innocent purchasers that clearly distinguishes it from the case.
It's not relevant to the issues, but what is the property?
Sorry?
What is the property? Is it a commercial building,
It's just a house. I don't, it's really odd in Wyandotte County. I do a lot of this work because it's probably hard for the court to believe that passing title without title work being done is very common in Wyandotte County.
Well, in
They-
other parts of Kansas too.
They
it happens.
they convey title to property on the back of a bar napkin and stuff. But what's happened in recent years in Wyandotte County is these properties that once had very little value are now worth a lot of money. And so I spend a lot of time doing quiet title actions.
Does it matter that all these conveyances were done by quit claim deed?
Well,
I thought quit claim deed means there's no guarantee you're getting good title here.
I had to look back on it, Judge, but the quitclaim deeds says you're conveying what title you have.
You get what I have.
Yeah. And she had the power to convey it, and like the court said, it's one word we're missing here. And after 14 years of other owners occupying the property, and after 14 years of other people paying taxes on the property, Judge Clapper felt that under equitable doctrines, they had a duty to come forward and do something. And now it has been 15 years now. Had I known it was going to be appealed, I would have waited a year. But it was only 14 years, Judge, when we filed the action. So I have nothing else unless the court has questions of me.
Was there any discovery to find the trust?
Well, I think, no, remember, she had no counsel.
Right.
So if she would have had counsel, I would have probably asked for a copy of the trust. But when you have cases against pro se litigants, filing for summary judgment is typically the course you take.
So there was no request for discovery? Or
I
production?
didn't request a copy of it, but they've never produced it. And that would be the logical thing to produce in a response to summary judgment. I still haven't seen a copy of the trust. So Judge, procedurally, had I done things differently, knowing as we'd be on appeal, I probably would have done that. But under the circumstances, until the very end, it was a pro se case. I'm just being candid.
Which we appreciate.
Okay. Okay,
Thank you.
thank you very much.
Let me reset my timer. You have 5 minutes.
Thank you.
Thank you.
I've never known the absence of counsel on the other side precluding a party from serving discovery. I've never known that. And as has been the pattern in this case, counsel for the appellee is making bland assertions, specifically he says that the people who received the deed were good faith. No, I think he said maybe innocent purchasers for value, something like that. There was no testimony or evidence. But as the court recognizes, a quitclaim deed is not a warranty deed. And if a person accepts title to a property through a quitclaim deed, do they not have some obligation to investigate if they want to secure ownership of this property free and clear? Counsel also said that these people may pay taxes, may have done a whole bunch of other things, and that may or may not be true. But I don't see anything in the record that makes any of those findings. I don't recall seeing anything. But again, the statute is clear. KSA 58A-810E states title in the name of the trust must be conveyed in the name of the trust with the trust name clearly set forth in the conveyance. To make any other assumptions about why this happened or why this did not happen is making negative inferences, which I don't think we're able to make in this case. And so again, we're just asking for a remand so the facts can be developed. My client says the property belongs to the trust. And as an heir of Marguerite Walker, deceased, and perhaps a beneficiary of the trust, we have the right to assert our claim. And the appellee plaintiff is not entitled to this property based on a quitclaim deed because this title is not superior. That concludes.
Thank you. We thank both attorneys, and again, like we told the parties before you, we'll take this matter under advisement and issue an expeditious leave.
I've been here years. Writing a brief was really hard if you haven't done one for 25 years. Thank you.